get down.
Hey everybody, welcome to the North Carolina Real Estate Show. I'm your host, Tiffany Weber. I'm an attorney at Thomas & Weber in Mooresville, North Carolina, and today I am joined by Erin Weatherman, who is also an attorney. I'm very excited that you're here with me today to talk about the North Carolina offer to purchase. Now, let's talk a little bit about buyer representation. So, Erin, take us through these things that the buyer is representing to the seller at the time of the offer.
So this is kind of like, how am I funding this purchase? So am I going to use cash? Those dollars that we talked about, not that hard cold cash, but USD, but not a loan. Or am I using a loan? And if I am using a loan, what type of loan? So that would be like a conventional or an FHA or a veteran loan, all of that. And then how much is my loan for? You hopefully got some form of pre-approval or pre-qualification before you started looking at houses. And so most of the time sellers ask for that. But this is where you say how much you intend to use in your loan.
Yes, and the buyer may be wondering, well, why is that any of the seller's business? Well, they're taking the property off the market. So they're losing the opportunity to sell to other buyers. And who knows, if you take 30 days, 45 days to, you either can't get the loan or you can't come up with the cash. The seller has given up 45 days worth of opportunities to sell this property to someone else. So, in fact, there's a note here that the people that made this form said, hey, if seller, you've got a buyer that's wanting to pay cash, we recommend you get verification of funds.
Yep.
So, even the North Carolina Association of Realtors and the Bar Association recommend to the seller, hey, find out that the buyer can actually either get approved for the loan by getting, the copy of the pre-qualification or pre-approval letter, or verification of funds for a cash purchase, so that you're not essentially wasting your time on a buyer that will never be able to complete the purchase.
So that next section B is other property. So does the buyer have to sell property to qualify for the purchase? This is where my kid understanding of property comes into play. I always thought buyers and sellers just switched houses. I didn't understand the process of, like, you moved into another house, but you still technically had your house and you were trying to sell it at the same time. So it just makes sense that you switch. But that's not how that
Don't worry,
happens.
she figured it out before law school.
Just a little bit before law school. And so that's where it becomes important as to whether you're going to make it a contingency that the buyer does have to sell their property. And so some people can't afford that mortgage for their current house and the new purchase at the same time. And so that's why this section is so important.
And it's also important, if you're an agent representing a seller, you know this, but to explain to your seller, hey, we have 6 offers in front of us. Some of them they're required to sell. They won't be able to qualify for a loan unless they sell their house.
Yep.
And then of the ones that are in that scenario, okay, well, this one, they're already under contract.
Yep.
This one, it's being actively marketed. This one, it's not even on the market.
Yep.
So there's so many different levels of determination that you go through, like which one's the strongest offer. It might be more attractive to seller. Okay, well, I like the one that's under contract. That's our safest bet if it's already under contract. And that, whatever makes the seller make their decision and their factors that go into decision making, that depends on the client themselves and, your counsel to them as their agent. But this is something to explain to sellers of, this is why this section matters. And buyers, if you're wondering, well, why is it in any of their business? Because they're using it to evaluate your offer.
Yep.
All right, now let's continue on with, these are again the buyer's representations, the things that they're representing to the seller at the time of the offer. The seller has some documents to provide. One is the Residential Property and Owners Association disclosure, and then the Mineral, Oil, and Gas Rights Mandatory Disclosure Statement. So these are things where the seller says the roof was replaced in 2017. No, there's no issue with the HVAC. So on and so forth. It's a several-page document where they basically talk about the condition of the home, any changes made to the home, But this is where the buyer says whether or not they've received a copy of that document.
Yep.
And if they have not received a copy of it, and there's no exemption from the seller providing it, then the seller still has to give that document over to the buyer.
Yeah.
And if they don't do that, by the end of the 3rd calendar day, the buyer gets another way to back out.
Yeah.
So that's kind of, one of those things. Get it before you go under contract. It's ready. The seller's done it. Their agent made them do it. So just get the copy before you go under contract. Now, let's talk also about the buyer obligations. This is paragraph 6. So these are the things that the buyer is responsible for. So if the buyer is buying the property and there are some special assessments that were lurking out there but had not been approved prior to closing, if they're approved after closing, this contract says, okay, it doesn't matter that they were lurking about when you went under contract. Once you close, if it's approved after closing, you're responsible to pay it.
Yeah.
That can sometimes, I'm thinking of examples like that neighborhood, The Point, where you can't do anything without the HOA approving it. If there's some special assessment for the pier that was proposed during the time of the contract, but it doesn't get approved until after the contract or after the closing, then the buyer is going to be responsible. Buyer also has to pay any costs related to their loan. There are some special things that the buyer can pay for HOA management companies. That's in a different paragraph. We'll talk about that in a later episode. Also, the buyer's going to pay for appraisal, title search, title insurance, the closing attorney's fees, the recording fee for the deed, and then preparing any of the documents that are going to secure the loan or make the loan possible. So that would be, deed of trust, loan docs, etc. Now, the reason I emphasize recording the deed, that's different than preparing the deed. So the seller is going to have to pay for preparing the deed, but the recording fee assessed by the Register of Deeds in the county, the buyer will pay for that. And then next, the buyer is giving permission to essentially release certain information to certain parties. So this lets the agents and the closing attorney give copies of the contract to the parties that are necessary in order for them to do their jobs, like the appraiser, closing disclosure, to give the closing disclosure to the agents, to the lenders, etc. So basically, if you're involved within the contract and the buyer's team, they're kind of giving permission for the buyer's team to share information. Erin, thank you so much for spending the time to go through this contract with me. Agents, hopefully you learned a little something or you picked up a nugget that will help you explain things to your clients going forward. This has been the North Carolina Real Estate Show, and we will see you in the next episode.